In the final module, we'll be looking at performance and discharge, the material in Chapter 18. And we're going to be talking about how one gets out from underneath the duty to perform in a contract. And so the most common way to discharge or terminate contractual duties is by the performance of those duties. Promises of performance are not expressly conditioned or qualified in most contracts. In most contracts, promises are absolute promises that must be performed. Some, however, some contracts do have performance that is required but conditioned. A condition is a qualification in a contract based on a possible future event. And the occurrence of this event, or it could be the non-occurrence of an event, that occurrence or non-occurrence will trigger the performance of a legal obligation. And there are three kinds of conditions. They are the conditions precedent or precedent. They are conditions subsequent or subsequent, and concurrent. And just for the record, you should note that you can have implied conditions and express conditions. So conditions precedent or precedent are conditions that must be fulfilled before a party has to do anything, before a party's performance can be required. Once the condition occurs, then that does require an absolute or gives an absolute duty to perform. The next time is a condition subsequent, and that is a condition that is fulfilled a condition that is fulfilled to terminate a party's absolute promise to perform. So the condition, once it is fulfilled, acts to terminate an absolute promise to perform. So the subsequent condition, generally, it does happen in the future, but when it happens in the future, it terminates the duty. In the condition precedent or precedent, you have a duty beginning when the future event occurs. Conditions concurrent, when each party's performance is conditioned on the other party's performance or tender. This is simultaneous. Simultaneous. And like I mentioned, we have express conditions and implied conditions. Look at the implied condition. It is understood to be part of the contract depending on the purpose. Sometimes courts will imply conditions or they will read by inference a condition from the purpose of the contract. The express is relatively straightforward. You'll have things like this. Party B has to do X if something occurs, or provided that something occurs. So express conditions are relatively straightforward to find. Implied conditions, in some senses, you might find them to be easy, and then others you might find them to be hard. If you said, I will hire you, I promise to hire you once you've passed the bar exam, there would be a condition precedent that was not only passing the bar exam, but was also that you get a JD, a Doctor of Jurisprudence. Why? Because you can't take the bar, at least in Texas, without that degree. So it wouldn't be hard to see that implied condition. Because the express condition is that you must pass the bar in Texas. Well, in order to pass the bar in Texas, you have to have an awarded JD. So you would have an implied and an express condition at the same time. We're talking about tender. That is an unconditional offer to perform. You might want to think about where else you've seen the word tender. If you were to pull out, let's say, a $5 bill, I have one here in front of me, you'll read some words on its front. It will say Federal Reserve Note. It says the United States of America. There's another number here. There's a signature by the Secretary of the Treasury. There's a series and a date. There's a picture of President Lincoln. And then there is also a statement under the United States Federal Reserve System seal that says This note is legal tender for all debts, public and private. And that's the same kind of word here, tender, legal tender. So if you were going to tender $5 and you handed someone a $5 bill, assuming nothing else was written, and someone says, no, 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 I don't want a $5 bill, you could counter and say, well, since it wasn't specified in the contract, by law, this note is legal tender, and so if it's $5, this counts. Maybe you've been to a gas station, and it says, no bill over $20 accepted. Well, that's okay too. So what about this legal tender question? So I'm not saying this is actually how the law would work, but I want you to think with me about this and how a court might review this. So I'm not telling you this is what the law is, merely thinking out loud with you. If you have a $50 bill, a $50 note, Federal Reserve note, and it says on its face, this is legal tender for all debts, public and private. And you only have a $50 bill and you're out of gas. And so you go up to the window, you knock, please let me buy gas. I'm going to buy $40 worth of gas, and you will only have to give me $10 back, but I only have $50. That attendant can say no because it's a policy of the business, right? Contractual freedom. Can't force someone to sell you something. And there's a sign, and they don't have to turn on the pump unless you can show something other than a $50 bill. If they say a $20 bill is the largest amount. But what if you did this? What if there was a sign, but you didn't see it, and then you actually pumped gas into your car, and you pumped exactly $50 worth of gas to the penny, but you hadn't paid for it yet. Once you've put that gas in your car, you owe the gas station, the business, $50. That is a debt. And if you were to take that $50 over to the window, and then that was the first time you saw this sign that says we only accept bills up to $20, nothing larger. The question for you is, could you demand that they take your $50? Could you call a sheriff's deputy and say, look, I have put $50 worth of gas in my car. This is a $50 note. It says it is legal tender for all debts, public and private. I am in debt and I'm trying to give it to them. I do not want to get a ticket or arrested for theft. And could you force them to take that $50 bill? So I would like to say, and I'm not telling you that I've researched this. I'm not telling you what Texas law says on this. I'd like to say they have to take it at that point because it is a private debt. It's just something I like to think about. If you want to do some research on your own and actually see if a court has determined this to be the case, you can. But tender is an unconditional offer to perform. There are two types of performance. We have complete performance and we have substantial performance. Complete performance is everything's perfect. All conditions are satisfied. Right? Complete performance. Then we have substantial performance, and this is where a party is in good faith attempting to perform substantially all of the terms in the contract. And this confers most of the benefits promised. What we do in substantial performance arenas or situations or context is we require the other party to perform even though we didn't fully perform. There is an opportunity to, let's say someone built you a house, and one of the requirements of the home was that they put in a garage door opener so that you had an automatic garage door opener. And so they built you this beautiful house, and let's assume it's a really nice house. It's a $500,000 house. It's a beautiful home. And they did everything except for the final installation of the garage door opener. Could you, as the homeowner, say, oh, I'm not paying you a red cent because you have not fulfilled your contract. You have contractual duties to perform, and I do not have to pay you until you've met those conditions of performance. You think you'd get away with that? Well, the answer is no, you would not. You would have to pay. Now, you might be able to pay minus the cost of the installation and the cost of the actual garage door opener, though. Right? So if you had to build a home and all you did was lay down the concrete, that's not even near substantial performance, and I would argue you have no duty to perform at all. Courts decide whether the performance was substantial, and they do this on a case-by-case basis. I gave you two pretty easy examples where I'm almost positive a case reviewed by a court, the court would find substantial performance. And then with the only pouring the concrete, no way that's substantial performance. But here's the effect. The parties must continue performing under the contract if it is substantial performance. That means you must pay. You would be able to probably subtract, this would be damages, the cost to bring the object of the contract in compliance with its terms, if that cost is reasonable under the circumstances, and that would be how much does the installation and the purchase of a garage door opener cost. Sometimes we have conditions that are to the satisfaction of another. If you hire someone in particular to come and sing, you can't substitute that. When you hire someone who has a good eye for decoration, you could say, I will pay you when this expert of mine is satisfied that everything is right. So your performance to the satisfaction of another. I will pay you for the house as soon as this expert walks through and says he is satisfied with the build. Most of the time, we do use a reasonable person standard. You can expressly state otherwise, though. We have things called a breach of contract, and I want to point this out. Sometimes in my classroom, I put more emphasis on this than is probably needed. But what do you do when you breach something? And what is it that is breached? Well, you breach a legal duty, or you breach a contractual duty. You breach duties. Now, we say breach of contract, but I would like to submit to you that breach of contract is a shortened form of the following. You have legal duties, and that's in tort law, for instance. You have a legal duty, and if you breach that duty and that breach causes damages or harm to someone, you have a negligence cause of action. A contractual duty only arises just because of the contract. And so you breach a duty that arises out of contract, and we shorten that to breach of contract. So you're breaching a duty. So when you breach a contract, you have to look for what duties were there and whether or not they were performed. There are two kinds of breaches, material and minor. Material and minor. Material breach is a large, big breach. Oftentimes, you will have something that says time is of the essence and will be considered a material part of this contract. Otherwise, you have a reasonable amount of time to get it done, and if you miss the deadline, it's probably not material, but you can make it material. Once the minor breach is cured, non-breaching party must resume performance of a contractual obligation. Here's the policy. Any breach entitles the non-breaching party to sue for damages, period. Only a material breach discharges the non-breaching party from the contract, however. Any breach entitles a lawsuit for damages. Only a material breach discharges the non-breaching party from the contract. One more time. Any kind of a breach, tiny little breach, material breach, any breach entitles the non-breaching party to sue for damages, but only a material breach discharges the non-breaching party from the contract. What if you haven't breached a duty yet? We have a doctrine in law that's called anticipatory repudiation, and that is the refusal of one party to carry out his or her contractual obligations before either party has a duty to perform. So I say, I promise to pay you $500 if you promise to mow my lawn on Friday by 5 p.m. If you say, I accept and I promise to do so, we have an executory contract. In fact, it's a bilateral executory contract. What if on Wednesday you call me and say, I am out of town, I had a death in the family, and I will not be there on Friday. I'm so sorry. I hope you can find someone else. Well, hopefully, I would say, I'm very sorry for your loss. Don't worry about it, and I would rescind the contract. But what if I knew you were lying and you were trying to play on my emotions and I knew you had no death in the family? You wanted to go to a concert. And so I thought, you're a big fat liar. And I said, well, so you're telling me you're not going to be there? You're not going to be there. I'm considering this to be anticipatory repudiation, and I'm going to sue you. And I go and I find the only other person I can find on short notice to mow my lawn, and it cost me $700 to have my lawn mowed, and so I pay him $700 to have my lawn mowed. I will sue you for $200 because I was already willing to pay $500. Because of your anticipatory repudiation, I had to find someone else, and it cost me $200 more than you were going to charge. So you owe me $200 for your breach of contract, even though you repudiated, or it was anticipatory. Your repudiation, I interpreted it, and it was only Wednesday. You still had 2 more days to mow my lawn. It's anticipatory repudiation. It is treated as if you materially breached the contract. There's a couple of key issues here that you will see maybe on the exam quiz. Notice by a repudiating party may restore parties to original obligations. But you have to give the party notice before someone has acted. So time for performance, if you remember, we have agreement, consideration, capacity, legality, and sometimes form. That the agreement element had 2 sub-elements, and that was offer and acceptance. And there were some what we might call sub-elements of offer. Number 1, in order to show that you had a legitimate offer or a legal offer, you had to have a serious intent to be bound, right? You also had to have definite terms. The terms had to be definite enough, and then you had to communicate it. Well, part of the proving up that the terms were definite were to identify the parties, identify the subject matter, identify the consideration, and the timing. If you don't put a time expressly in your contract, courts will imply you meant a reasonable time. So it's still there, but it's an implied term. And unless time is expressly stated as vital, like time is of the essence, this is a material part, that will be considered a non-material breach. And this is what I was talking about. If time is of the essence, it can become a condition precedent to performance. So there's a couple other ways to get out from underneath it. One is by rescission, by agreement. Parties must make another agreement that also satisfies the legal requirements for a contract, offer, acceptance, and consideration. Rescission of most executory contracts is enforceable even if agreement is made orally. Oftentimes you will have a very fancy, well-written contract, and it will say the only kind of modifications that will be effective are written modifications. You cannot modify this contract unless it is in writing. It will be bold. Everyone will have to sign it 10 times each. Everyone will see it. Guess what? It doesn't have to be in writing. Because you can always have a contract that's enforceable that's oral. But that does scare people, right? And it does create a policy and behavior. But you can always orally rescind a contract, even if it says you can't. Under the UCC, contracts must be in writing. This is the UCC, not common law. Rescission of contracts involving transfers of realty must also be in writing. And then, if one party has performed, agreement to rescind must have additional consideration. So there's the general rule, and then some additional rules here. Novation. Novation. This is a substitution of a human, of a third party, or of a corporation, right? It could be an individual who's a corporation, something like that. But it's a substitution of a new third party for one of the original parties. So person A and person B have a contract. Person B says, I really don't want to perform, but person C does. can we just make this contract about A and C? And you can. The novation extinguishes all the old obligations and creates new obligations. But it looks like and is legally effective as if you just moved person B out of the situation and person C into it. But it's perfectly legal. You do it all the time. You can also have a discharge by settlement agreement, such as an accord satisfaction, maybe. And this is a compromise that arises out of a genuine dispute, oftentimes a lawsuit over obligations under the existing contract, and a discharge by settlement agreement is recognized at law. And then this is the specific version of accord and satisfaction. This is a new contract to perform existing contractual duty not yet discharged. And then performance of the accord brings about the satisfaction. Once the accord has been made, the original obligation is only suspended until the accord agreement is fully performed. So in the context of a credit card debt, you might have a credit card company says, you owe me $10,000, or you owe us $10,000. And you say, look, how about this? You say I owe $10,000. I don't think I owe that much. I'll pay you $2,500 right now to discharge the previous debt. And they agree to it. Then as soon as they agree, the $10,000 debt is suspended. And as soon as you finally perform by tendering $2,500, then the old debt is extinguished, as well as the duty to perform the $2,500 payment, accord and satisfaction. If there is a material alteration and you're an innocent party, the innocent party is discharged after a material alteration. Material alteration. Statute of limitations. Remember, this is one of those enforceable to unenforceable transitions. You have a perfectly good, valid contract. Someone breaches it. You wait for 4 years and a day. The statute of limitations has run, and it may be a good contract. It's no longer enforceable. And then bankruptcy. You file for bankruptcy protection. The bankruptcy court can discharge a debt. And that usually prevents creditors from enforcing most of the old contracts, the debtors' contracts. Sometimes we have the impossibility of performance, and that really only applies if the event that is supervening was not foreseeable. There are two kinds of impossibility. One is objective impossibility. It flat out can't be done. From subjective impossibility. I just can't do it. There are some situations that may allow for discharge of contractual obligations when performance is sort of logically impossible. One party to a personal contract dies, or the specific subject matter of the contract is destroyed. It's not about impracticability, it's impossible, logically impossible. There are types of situations that may allow for discharge of contractual duties when a change in the law renders performance illegal. So it's legally impossible to perform. And if it's merely temporarily impossible to do something, you're generally talking about a delay. Sometimes this is really up for the court, and it's on a sort of a continuum. But if the lapse in time or the change in circumstances surrounding the contract makes it substantially more burdensome, then sometimes the law will allow the contract to be discharged. Then we get to commercially impracticability or commercial impracticability. And this is where it no longer makes economic sense. And if this changes for a foreseeable reason, it may not be enough to discharge it. So the price of oil, it fluctuates and it makes it impracticable. Well, if there was a terrorist activity that blew something up, maybe that would not be foreseeable. If it's merely just a shift in the price of oil due to normal circumstances, that may not be enough. A contract will be discharged if supervening circumstances make it impossible to attain the purpose both parties had in mind when they made the contract. So this frustration of purpose and these are rare. I don't think I've ever seen an allegation of frustration of purpose outside of the academic world, although that doesn't mean much. But frustration of purpose when neither party is going to get what the aim was in the beginning because something happened. Frustration of purpose. So just look at these. We have different ways to discharge: discharge by performance, discharge by agreement, by a failure of a condition, by operation of law, and by breach. It's a good short picture or exhibit. It's -18-3 rather, about how to discharge a contract. And you should highlight this. It might be helpful when you're taking your quiz or an exam.